So this morning, we're going to talk about data challenges and appeals under the Data Practices Act. We've seen a steep increase in these appeals, so it's important for entities to be aware of these processes. I'm going to give an overview of the relevant provisions in the Data Practices Act, and then we will also discuss what is the actual process for an individual to challenge the accuracy and completeness of data about themselves. And we'll save a few minutes at the end for questions. We always like to begin with a little bit about our office in case you are not familiar with us. The Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to these laws from members of the public and from government. So if you have a question about either of these laws, please feel free to reach out to us at any time. We answer those questions via phone or email. We also assist the Commissioner of Administration with issuing advisory opinions, and we provide legislative assistance and training. This PowerPoint is posted on our website. The slides are on the page where you registered. If you see the toggles for presentation slides, they are under the toggle for other data practices and OML guidance webinars. We also record our webinars, so if you miss part of today's discussion or you want to go back and watch it again, or you want to see one of our previous webinars, those will be posted on our Data Practices Office YouTube page. You can find more information at the link listed on this slide, and then we'll also have a slide later with specific links to those resources. Here is a look at today's agenda. The first 35 minutes will be an overview of the data challenge and appeal process. And then we'll leave about 10 minutes at the end for questions. You can wait until the end to send in your questions, or you can send them in as you think of them. To send in questions, please use the Q&A panel. To get to the Q&A panel, you'll select Q&A at the top of your screen on that top menu bar. If you don't see a Q&A option, you may need to click the More button, which is the 3 dots on the top menu bar in Teams. All right, so let's jump in. We'll start with the foundation laid out in the statute. So the right to challenge data spurs from the requirement that data that government maintains about individuals be accurate and complete. Minnesota Statutes section 13.05, subdivision 5, requires the responsible authority to establish procedures to assure that all data on individuals is accurate, complete, and current for the purposes for which it is collected. Note that this requirement is specifically for data on individuals. Section 13.02 defines individual as a natural person. So that means that data on individuals are data about living human beings. The data challenge and appeals process is set out in Minnesota Statutes section 13.04, subdivision 4. We will start with the data challenge process. Before there can be an appeal, there has to be the initial challenge to the accuracy and completeness of the data. Section 13.04 of the Data Practices Act gives an individual subject of government data the right to contest the accuracy and completeness of public or private data about themselves. This applies to individuals. As we talked about under section 13.02, the definition of an individual means a natural person. But also in the case of a minor or incapacitated person, an individual also includes a parent or guardian. The person who is submitting a data challenge must be the subject of the data, meaning that the data they are challenging are about them. Or in the case of a parent or guardian, those individuals can also challenge data about their minor child or the person they have guardianship over. So in those situations, the parent or guardian is stepping into the shoes of the minor child or the person who has a guardianship over them. So that is how they are able to challenge data about those individuals. Otherwise, you can only challenge data about yourself. Only public or private data are subject to challenge. Confidential data are not. So as an example, active criminal investigative data are classified as confidential. So if law enforcement was investigating me for some reason, I could not challenge the accuracy of active investigative data they have about me. Those data are classified as confidential and they are not subject to a data challenge. Additionally, the challenge data must be capable of being proven false. So this is usually going to be a statement of fact or an opinion or judgment that rests on a statement of fact. Previously, we thought that opinions could not be challenged, but in Schwenke versus Minnesota Department of Administration, the Minnesota Supreme Court reasoned that some opinions and judgments rest on statements of fact that are objectively verifiable and thus capable of being proved false. In that case, one of the statements that Schwenke challenged was that his refusal to participate in a team building exercise at a staff retreat shows that he is not a team player. The court reasoned that because the subjective statement about not being a team player rested on a factual assertion that this individual refused to participate in the team building exercise, that part about his refusal to participate was capable of being proven false and could be challenged. However, the court did clarify that mere dissatisfaction with a subjective judgment or opinion cannot support a challenge under the Data Practices Act. To challenge data under Section 13.04, a data subject needs to follow the process laid out in the statute. The first step to contest the accuracy or completeness of data is to file a statement of disagreement with the government entity that has the data in question. This statement must be in writing, and it must be sent to the entity's responsible authority. It needs to describe in detail the data that are being challenged, state why the data are inaccurate or incomplete, and state how the data should be changed. To determine which employee is the responsible authority for a given government entity, individuals should look at Minnesota Statutes Section 13.02, Subdivision 16, or also the entity's data access policies usually set that out as well. One exception to this process is for direct care and treatment sex offender program challenges. If someone in that program wants to challenge data that DCT maintains about them, they're required to submit their challenge to the Data Practices Compliance Official for DCT. So for all other challenges, those are going to be sent directly to the RA, but for MSOP DCT challenges, those are sent to the DPCO of DCT. Once an individual challenges the data, the government entity must respond. After receiving the statement of disagreement, the responsible authority has 30 days to review the contested data and make a determination regarding the data's accuracy and completeness. In response to a data challenge, the entity has two options. The first is that the entity can complete, correct, or destroy the data. If the entity does so, it must also attempt to notify all past recipients of the correction. The second option is to notify the data subject that the data in question are complete and correct. If the entity makes this determination, it must also inform the data subject that they have the right to appeal this determination to the Commissioner of Administration. Note that Subdivision 4C also requires that if the government entity discloses the disputed data, it must attach a copy of the statement of disagreement whenever the disputed data are disclosed. This requirement applies until the time to appeal has expired or until the appeal is resolved. So if someone has challenged data and the entity has determined that it's complete and correct, that individual has a period of time to appeal that determination. During that time, if the entity is asked to disclose the disputed data, they have to include a copy of the individual's statement of disagreement or their data challenge that they submitted to the responsible authority that says why they think those data are inaccurate or incomplete. Section 13.02, subdivision 4G, specifies that data on individuals that have been successfully challenged by an individual must be completed, corrected, or destroyed without regard to the requirements of Section 138.17. Section 138.17 is the Records Management Statute. So this means that even if the data are part of an official record that's listed on the entity's retention schedule, if the challenge is successful, the data can be altered or destroyed regardless of those requirements. This alteration or destruction can happen when the data are challenged, or it can happen later on in the data challenge appeal process, either by agreement of the parties as to how the data should be changed, or by order of the commissioner. Once there has been a data challenge and the responsible authority has made a determination about the accuracy and completeness of the data, a data subject can file a data challenge appeal with the Commissioner of Administration. This process is also laid out in Minnesota Statutes section 13.04, subdivision 4. Under this section, a data subject may appeal the responsible authority's adverse determination as to the accuracy or completeness of the data to the Commissioner of Administration. Appeals must be submitted in writing, via mail, or email. And I'll note that the Data Practices Office processes these appeals on behalf of the Commissioner. In this appeal, the data subject must in submitting the appeal, the data subject has to submit it within either 60 or 180 days of the responsible authority's determination. So if the responsible authority notified the data subject of their right to appeal in writing, which is required by the statute, as we talked about, then the data subject only has 60 days to appeal. However, if for some reason the responsible authority fails to provide this notice, then the data subject has 180 days to appeal. These deadlines are set out in Minnesota Rule 1205.1600. Remember that under Section 13.04, Subdivision 4C2, the entity is required to inform the individual of the right to appeal the determination to the Commissioner. So really, in all scenarios, it should be that 60-day deadline that applies because the entity is required to notify the individual of their right to appeal. When a data subject submits an appeal to the Commissioner of Administration, there are some required items. The appeal letter must include their name and their mailing address, the name of the responsible authority and government entity, a description of the dispute and of the data in question, and a description of the desired result of the appeal. So what is the data subject looking for? Do they want the data destroyed? Do they want certain redactions? Do they want a supplement? We need to know what they want to come of the appeal. The appeal must also include copies of the disputed data in its original context. So this means basically a copy of the document where the data appear. We also need a copy of the individual's data challenge letter that they submitted to the RA and a copy of the RA's determination. We have detailed instructions on submitting an appeal on our Data Challenges Appeals webpage, which is linked on this slide. When our office receives an appeal, there are initial steps we take. First, we review the appeal for completeness. If the appeal is incomplete, we will send the data subject a letter explaining what documents or information we need in order to process the appeal. If the appeal is complete, then we begin processing it. As soon as we receive an appeal, we also notify the entity that we are in receipt of an appeal. There's nothing that an entity needs to do when they receive this notice. This is really our first communication to the entity that lets them know that someone has appealed their determination. We will follow up with information about next steps as we process the appeal. Under Section 13.04, Subdivision 4E, the Commissioner has discretion to dismiss an appeal without first attempting to resolve the dispute or before issuing an order and notice of a contested case hearing if one of three specific grounds for dismissal exist. The Commissioner has discretion to dismiss if, 1, the appeal to the Commissioner is not timely, so it was not submitted within either that 60 or 180-day deadline. The second ground is where the appeal concerns data previously presented as evidence in a court proceeding in which the data subject was a party. Or the third ground is that the individual making the appeal is not the subject of the data challenged as inaccurate or incomplete. So the data that the person is trying to challenge is not actually data about them. Either party can provide our office with information relevant to dismissal at any time before the case is referred to the Court of Administrative Hearings. Particularly with the second ground for dismissal, where the appeal concerns data previously presented as evidence, that's not something that our office is likely to know unless the parties provide information about those proceedings to our office. So if you would like us to consider discretionary dismissal on one of these three grounds, we do encourage you to submit relevant information to our office. The Commissioner does not have authority to dismiss an appeal before sending to the Court of Administrative Hearings for a contested case hearing for other reasons. So in Schwanke, the Minnesota Supreme Court discussed our obligation to send these appeals for a contested case hearing unless we have statutory authority to dismiss before that time. So if one of these three grounds do not exist, and if informal resolution is not successful or the appeal is not withdrawn, we are obligated to set the appeal for a hearing at CAH, no matter what we think about the underlying data challenge. So there's not other arguments you can make that can lead us to dismiss the appeal before that time. We are limited to these three statutory grounds for discretionary dismissal. Once we receive a complete appeal, the next step is to offer the parties the opportunity to participate in the informal resolution process. Section 13.04, Subdivision 4, requires the Commissioner to try to resolve an appeal informally before issuing an order and notice of hearing. That said, for the parties, this is an optional process. So if either party refuses, the Commissioner will issue an order and notice of hearing. The parties may voluntarily resolve the data dispute at any time prior to the hearing under Minnesota Statutes Section 14.59. So if it gets referred to CAH and the parties are able to resolve it between themselves before it actually goes to hearing, that is permitted under Section 14.59, but the informal resolution process is the process at our office where we ask the parties if they'd like to participate in this process, and if they do not want to, or if it's not successful, then we do refer the matter to CAH. When is IR likely to be successful? IR is what we call informal resolution. So successful IR generally involves compromise. It's more likely to be successful when the data are old or beyond the scope of the retention period, where the data are immaterial to the larger purpose for which it was collected. So an example is where there's the use of a particular term in the data, which the data subject finds offensive, but that term is not the basis for any determination by the government entity. It's just kind of what was used in the report. That might be something that the government entity is willing to redact or change. Another situation where IR could be successful is where the amount of data is large or of several different types, allowing the responsible authority to make an offer to change, redact, or destroy a portion of the challenged data. Generally, to be successful, the entity has to be open to changing the data. Additionally, the data subject has to be open to compromise. If the data subject will only accept an offer of an informal resolution that gives them everything they asked for in their data challenge appeal, it's unlikely that IR will be successful. Sometimes data subjects are open to compromise. For example, while they may really want an entire record to be destroyed, they might agree to redaction of certain portions of the data or the addition of a supplement that gives more context to the data. Participating in the IR process is voluntary, so either party can decline to participate, and no is an okay answer. A few reasons the parties might decline to participate in IR is that they don't want to, they are not open to compromise, or the entity believes the data are accurate and complete, and they want or need to maintain it. I do have a little caveat here to remember that data that have been successfully challenged can be altered or destroyed without regards to records retention requirements. So entities can think about why they need to maintain the data. If it's only to comply with Section 138.17, the Records Management Statute, entities might consider whether an informal resolution could be reached. If informal resolution is refused or unsuccessful, the commissioner shall dismiss the appeal or issue the order and notice of hearing. Note again that the commissioner's discretion to dismiss is limited to those grounds set out in Section 13.04, Subdivision 4E, as we discussed earlier. So that means that in most cases, if IR is unsuccessful or refused, the commissioner will issue the order and notice of hearing. The commissioner must give both parties reasonable notice of the hearing and state the issues that will be considered at the hearing. This order and notice will set the date and time for a pre-hearing telephone conference with the assigned administrative law judge, ALJ, and the actual hearing will be scheduled at that time during that pre-hearing conference. The notice and order will also state the issues that will be considered at the hearing, and a copy of the record will be sent to the ALJ and both parties with this notice and order. So that record is everything that our office has received in processing this appeal so far. So it will have the data subject's appeal, it will have communications we have between the data subject and with the government entity, and any sort of informal resolution back and forth communications that we had with the parties as well. Minnesota Statutes section 14.57 to 14.62 set out contested case procedures under the Administrative Procedure Act. So that's where the parties should look for information about procedures that are going to govern during this contested case hearing process at CAH. At the contested case hearing, the data subject has the burden to prove that the data in question are inaccurate or incomplete. All evidence submitted at the hearing becomes part of the case record, and neither the ALJ nor the commissioner will consider evidence which is not included in the official record. A closed hearing may be conducted to consider data that are classified as not public. The parties need to request this from the ALJ if they would like a closed hearing to consider not public data. Following the hearing, the ALJ issues a report and recommendation to the commissioner. These recommendations are not binding on the commissioner, who must make the final determination regarding the appeal. I also want to note that CAH costs are billed directly to the entity, consistent with Minnesota Rule 1205.1600. So the entity is responsible for bearing the costs that come through this contested case hearing process. After the ALJ issues their recommendations, the parties have an opportunity to file exceptions. Exceptions are an opportunity for the parties to address any specific errors or omissions that they believe are in the ALJ's findings or conclusions. Our office sends a letter notifying the parties of the opportunity to file exceptions. The parties do not have to file exceptions, but if they want to, they typically must be filed within 30 days of the date of the letter. The letter that we send you will specify when exceptions are due. After reviewing any exceptions, the Commissioner issues the final order, including findings of fact and legal conclusions. The Commissioner must issue the order within 90 days of record closure. The record closes either the date the last exception to the ALJ's report is received or the deadline for filing the exceptions, whichever is later. In issuing the final order, the Commissioner may adopt or reject the ALJ's recommendations, and this order is the final decision on appeal. In most cases, the data challenge appeal process is completed after the Commissioner issues the final order. However, either party may appeal the Commissioner's decision to the Minnesota Court of Appeals. To do so, the petition must be filed and served upon all parties, including the Department of Administration, within 30 days of receiving the Commissioner's opinion and order. This kind of appeal involves complex legal issues, so the parties may wish to consult with an attorney. To conclude, we have an overview of the main steps in the data challenge and appeal process. So first, the data subject submits a data challenge to the entity. Next, the government entity is required to respond. Then the data subject can submit an appeal to the Commissioner of Administration. When we begin processing the appeal, our office will offer the parties the option to participate in the informal resolution process. If the parties reject that invitation or informal resolution is unsuccessful, then the Commissioner will issue an order and notice of hearing at CAH. Once the appeal is at CAH, that's where it goes through the contested case hearing process, and the ALJ will issue their recommendations. The ALJ sends those recommendations to the Commissioner, and the Commissioner is the one who issues the final decision on appeal. And then lastly, either party can apply for judicial review of the Commissioner's decision. I want to note that while there are some deadlines set throughout the process, there's not a standard timeline for how long an appeal takes. Some appeals get wrapped up in a matter of months, while others have stretched years. This process can really vary depending on the preparation of the challenger, the complexity of the issues, whether the parties participate in that informal resolution process. It's hard to say how long that informal resolution process could last. And it can also vary depending on CAH procedures when they're setting these hearings for, if there's any continuances, things like that. I have a couple additional resources here. So the DPO website has web pages that provide additional information about data challenges and appeals. You can get to it through that link there, and it has step-by-step instructions on submitting a data challenge or a data challenge appeal. And the Minnesota Court of Administrative Hearings has a contested case guide available on their website. This is helpful for individuals who are participating in the process, and also if you're a government entity who has not gone through a contested case hearing, it can be helpful just to look at some of those FAQs that they have there. All right, we will start opening it up for questions. If you have questions, please submit them in the Q&A panel. As we talked about, the Q&A panel should be on the top menu bar of your screen, but if you don't see it, you may need to click the More button, which is those 3 dots. If we don't get to your question, we will follow up with you afterwards. However, there is an option to submit your questions anonymously. We are fine and happy to answer anonymous questions, but if we don't get to your question today and you've submitted it anonymously, we don't have a way to follow up with you. So we will need you to reach out to us via phone or email if you would like us to follow up with that question. A few additional reminders. The slide deck is available on our website, and you can access the recording on our YouTube page within the next day or two. I'll also put the evaluation in the Q&A panel here shortly. It's a link to a form, and if you can fill that out and let us know how we did and what other topics you'd like to see in the future, that really helps us out.
Okay, so we can hop in here with some questions. And the first one that we have is one that I have not uh, seen before, and so this is a good one. Can you challenge a deceased individual's data? And so I think this gets a little technical, and you have to jump to a different section to start with to think about this question. And so 13.10 is the section of data on decedents. And so that's the section that basically says when you have private or confidential data on an individual and then that person dies, those data are no longer technically data on individuals. And so what that happens is those become private data on decedents, or confidential data on decedents. And so, to the extent that someone is challenging data on a deceased individual, I think that person would need to be the representative of the decedent. And so we're looking at 13.10, subdivision 1C. It defines who the representative of the decedent is. And then when you go down to subdivision 3, what it says in there is that, any of the rights conferred by this chapter on individuals who are the subjects of private or confidential data shall, in the case of private data on decedents or confidential data on decedents, be exercised by the representative of the decedent. So if you have some private data that are incorrect, I think they're probably the representative of the decedent probably can exercise these data challenge rights. And so, again, not anybody can come up and just say, hey, I think this data on this deceased individual is incorrect or incomplete. It would need to be the representative of the decedent who is doing that, because they are the person who can exercise the rights on behalf of that deceased individual. And so I think it's probably possible, probably rare, but if you're a government entity and you're receiving this challenge and the person is deceased, you'd probably need to go through that process of confirming that the person making the challenge is the representative of the decedent and exercising their rights to challenge the data under 13.04 via 13.10 subdivision 3. So yeah.
Okay, I'm going to take a couple questions in succession here. So one question is, when an individual submits a challenge, is their challenge provided to the agency? And so there are two pieces to the challenge and appeal process. There's the challenge and then there's the appeal. So the challenge goes directly to the government entity that's holding the data. So we at the Department of Administration don't necessarily know that you're receiving challenges, because the responsible authority at that agency is going to decide, is this data about the person, and is it correct? Is it accurate and complete? So we generally don't hear about it at the Department of Administration until it rises to the level of an appeal. So the individual submits the challenge to the entity, and that's who takes care of it at the challenge. And so if it's just something that can be easily changed, the Department of Administration will never hear about it, because it will just be changed at the agency or the entity that's maintaining it. The second question is, does the Department of Administration ever tell the challenger that you won't hear it or that there is no issue? So again, the challenge is going to go to the entity. The entity is going to make those kind of threshold determinations. So for instance, if I submit a data challenge about Casey, you can say, you can't challenge data about somebody else. That's not a thing that you can do. So you can't challenge that. If they then come to us and say, I challenged this data and they wouldn't, the entity wouldn't let me do it. Yes, we would explain that that's not a proper data challenge. You can't appeal that because you can't challenge it in the first place. So the one area where I would say there is a possibility that we would take something is around the determination about whether data are about the person that's asking. So if you have a situation where there's a challenge and you're trying to determine, is it about the person that's asking? Is it data not on individuals? What is it? Is there some room there? Please reach out with your data challenge to us and we can kind of talk through that. So we're all kind of on the same page and have the same game plan about whether or not appeal is appropriate, and or whether or not when it comes to admin as an appeal, if it does, we have the discretionary authority to dismiss it.
Okay, next question. Would the commissioner likely dismiss or accept an appeal challenging an incidental statement about a parent when the data itself is about their child and not the parent? The statement in question does relate to the parent, but not the entirety of the decision itself. And so I think just ditto to what Taya said there on that front. I think there would have to be some discussion, and so top level, it depends. I don't want to say whether we'd be likely, whether the commissioner would be likely to dismiss or accept an appeal specifically. It really depends on that question of whether that person challenging, that individual challenging the data is the subject. And so, a data subject is not, or an individual is not a data subject if it's clear that they're incidental to the data. And so we would want to have some sort of discussion. So if there are some situations that you're thinking about, reach out to our office and we can certainly chat with you and kind of, as Taya said, put together kind of an understanding of whether that or not that person is the data subject. But again, I can't say for certain one way or the other or what is likely or what is unlikely.
All right, we have somebody asking if the cost shifts if the government entity prevails on an appeal. So as far as those CAH costs go, there is no shifting of those costs. Those costs are billed directly to the entity, and the entity is the one responsible for paying for the contested case hearing process. That's the way it is set up in our rules. And there isn't a process where if someone's appeal is not successful, that those CAH costs would then be put on that individual. Through this process, it really is the entity who's responsible for those CAH costs.
Okay, I have a couple more here. One is, are there legislative efforts to provide additional off-ramps for discretionary dismissal of data challenge appeals? At this time, we don't have any plans, but we are always looking at this process to determine what's the most efficient for both data subjects and government entities. So if you have thoughts or ideas or proposals, definitely send them our way. We are always trying to, again, look at this through an eye of continuous improvement. We are getting more appeals than we have before, as Grace mentioned. And so the more that we have, the more often that we're processing them, different issues come up and we realize that maybe we need to address something in statute. So if you have ideas, please send them our way. The other question I have is, do entities get a copy of the appeal letter submitted by the data challenger? Yes, when we receive an appeal, we let the entity know that we have received an appeal. And then we go through our process here to, again, determine do we have discretionary authority to dismiss, or do we go forward with informal resolution? So you will get, if you're an entity that is the subject of a data challenge appeal, yes, you will get notice that we have it.
Okay, next question. How frequently does this process occur? I assume you mean the appeals process. It depends. It really depends on whether folks are reaching out to us and making these appeals. I did just, I think, a quick count of we've received about 13 or 14 appeals so far this year. Sometimes the same person submits multiple appeals if they're challenging data at different entities, or maybe the same entity and its different issues. And we sometimes will consolidate those appeals. But yeah, I think we've received about 13 or 14 or so this year. That's quite a few. Last year, I think maybe we received about 17, 18 or so appeals last year. So we are seeing increases in numbers in the number of appeals that we're receiving. But the data challenges just generally, I imagine that they are happening more than we know, mostly because we only see the situations where folks are want to dispute the entity's determination. But I imagine that there may be a lot of situations where the entity just made a mistake and there is some incorrect data, and rather than disputing it, the data are just corrected, and so the process works probably more often than what we get to see, because we only get to see when people are not happy when the process works. But yeah, so we are seeing an increase in the number of these. So again, yeah, it's just kind of that's hard to say certain numbers, but there has been an increase over the past couple of years in the number that we've seen.
Just to clarify my last answer, yes, the entity will get the appeal as well, so that so they can see what is being appealed and sort of the arguments that the data subject is making.
Yeah, just following up on that, we can, if you want a copy of the appeal letter earlier, that's certainly something we can provide. Sometimes when we work through the informal resolution process, we're able to to provide a copy of the record so far to both parties. And then also, like I said, when it goes to CAH, we provide a full record to the parties and the ALJ, and so that record will have the appeal in it. Okay, I published one down here. Let's see. What guidance would you give about handling a challenge to data that is very old and little or no additional information is available? All available employees have left, etc. So for this question, I think you might consider whether this is something that can be resolved in informal resolution. You can think about why you are maintaining this data and what the importance is to the data. It might be a situation that you don't actually need to maintain that data, or the changes that they're asking for wouldn't really affect anything at your entity. Otherwise, I think you're going to have to look back in your other records around that time to try to verify the accuracy or completeness. When all the employees have left, I think it gets tough. There are situations where employees leave who wrote reports, and then they're kind of called back during these processes to verify that they wrote the report or something like that. But it can be a challenging situation, and I would just say consider whether it's an opportunity to informally resolve that or not.
Okay, we have a question that says, once an entity responds to an initial challenge and the period to appeal has run, are future challenges by the same subject, by the same data subject barred by claim preclusion? At this point, I think that the way that a data subject and an entity kind of goes to the end of this process is to engage in that appeal process. So they can basically keep challenging it to you, but if you continue to say that it's accurate, you'll have their statement of disagreement that's going out with that data as long as you're maintaining it as a disagreement to it. But the way the data subject really kind of gets to that final point would be to appeal to the commissioner and either get a formal dismissal or get or go through the CAH process.
All right, I think we are at time today. I see there's some questions about not receiving an individual's appeal. If that's happened, feel free to reach out to me at grace.barron@state.mn.us, and we can figure out what's going on with that appeal for you. Like I said, usually the full record gets sent when we send it to CAH, but if you want a copy of that appeal record before that time, we can provide that to you. Otherwise, thank you very much for joining us today, and we will follow up with other questions that we didn't get to today. Thanks, everyone.